And the respondent to the judge's talk will be Dr. Sigall Horovitz. Dr. Sigall Horovitz is a postdoctoral fellow at the Minerva Center for the Rule of Law under Extreme Conditions in the University of Haifa. Her research areas include transitional justice and international criminal law, with a special focus on Africa and Israel-Palestine. Dr. Horovitz holds a Master of Laws from Columbia University and a Doctor of Laws from the Hebrew University of Jerusalem. Her doctoral dissertation focuses on the impact of the ICTR on national reconciliation in Rwanda. Prior to her doctoral studies, Dr. Horovitz worked for the UN as a legal advisor at the ICTR in Tanzania and the Special Court for Sierra Leone. Dr. Horovitz directs university projects on transitional justice, and she initiated the transitional justice programs at both Tel Aviv University and the Hebrew University. She also develops and teaches courses on transitional justice and on election and party law. Dr. Horovitz is a recipient of the Arthur Hilton Fellowship of the American Society of International Law, the Rabin Scholarship of the Truman Research Institute for the Advancement of Peace at the Hebrew University, and the Voters Prize of the Institute of Contemporary Jewry at the Hebrew University. She is a member of the New York and Israeli Bar Associations and a founding member of ALMA, the Association for the Promotion of International Humanitarian Law. The floor is yours, Dr. Horovitz.
Thank you very much, Professor, and thank you to the organizers of the conference. I'd like to give special thanks to the president of the ICTR, Judge Janssen, for his wonderful address. I think for a lot of us who don't know so much about the ICTR's jurisprudence and the ICTR's activities, are now aware of these activities after such a clear explanation, including the cultural context and the challenges. So I'll try to keep it short. I'll try to address this issue of the ICTR's contribution to reconciliation, which Judge Janssen mentioned was part of the mandate of the ICTR. Now, we've heard a lot about the judgments, about the judicial notice of the genocide, about convictions of genocide architects, about sexual crimes being a form of genocide. This is a lot of the case law that came out of the International Criminal Tribunal for Rwanda. This is case law that is a condemnation. It reflects a condemnation on the international level of the genocide in Rwanda. And usually when you'd ask international jurists, and in particular staff of the International Criminal Tribunal for Rwanda, how would your jurisprudence contribute to national reconciliation? Off the hand, the normal answer, automatic almost, would be recognizing the genocide by an international tribunal, by an international judicial body, is condemning these acts, is remembering these acts, is commemorating the victims. That in its own right would contribute to national reconciliation. There are many theorists also of criminal justice that would argue that judicial proceedings against perpetrators would satisfy many victims that would otherwise want to seek revenge in illegal ways. So by adjudicating crimes, you remove the edge of violence, or you relinquish these revenge sentiments. On the other hand, there are many critics who would argue the opposite. And with regards to the ICTR, especially being an international institution far removed from Rwanda, with all the attributes that were discussed before, with no Rwandan judges, with no Rwandan penalty structures, that could actually operate in another way towards Rwanda, that could be viewed in Rwanda as some kind of external Western imposition, some kind of interference in our own domestic affairs. And in fact, it was viewed this way in Rwanda. Others would argue more generally that criminal courts, whether national or international, are meant to deal with very particular cases, very particular acts, very particular persons, defendants, victims. And therefore, they miss the broader picture. They do not address societal dynamics and more broad historical context. And therefore, these are not the right mechanisms to address political, societal processes such as reconciliation. They deal with very, very individual events. With regards to the ICTR and other criminal systems that follow the adversarial system, the Anglo-American system, those justice systems that follow the Anglo-American system do not give room for victims to participate in the process, like our system here in Israel. And therefore, these mechanisms are even less equipped than other kinds of justice systems to address issues of national reconciliation. They marginalize the victims. Some would say they re-victimize or re-traumatize victims by not giving them a voice and not giving them a stage and not giving them any reparations. You know, those here who come from Europe know that courts there do give a right to victims to participate actively in the proceedings and to get reparations as part of the criminal justice system and proceeding. The ICTR, following the adversarial system, the Anglo-American system, doesn't give this stage to victims or reparations to victims. So many of the tribunal's critics said, well, if you wanted to address reconciliation, the very basic thing you should have done is given a voice to victims and given reparations to victims. Yes, victims did appear as witnesses on behalf of the parties, but they were not given their own autonomy. They had to follow the lead of the party that they were speaking on behalf of. Some people even claimed that the tribunal had undermined reconciliation in Rwanda, as it risked the security of some of those who testified, and it also re-traumatized some of those who gave evidence. It didn't have the capacity or the institutions to have a more rehabilitating approach. I think the tribunal itself took into consideration this criticism, and with the years it added a little bit more support on the psychological, social dimension to the testifying victims who came and testified as witnesses. Then there was the issue of the outreach program that the president had mentioned here. Through that, also, the tribunal tried to address some of these concerns. And through a program that operated in Rwanda, which was called the outreach program, the tribunal tried to explain to the local population in Rwanda about its activities and why these activities are actually good for Rwandans and why justice on an international level would be a powerful instrument on the national sphere. Now, some of these messages registered, but a lot of them got lost in the environment of a very contradictory message, I think, that was projected by the leadership and by civil society in Rwanda. Messages that were antagonistic towards the court, messages that, again, viewed the court as a Western, imperialistic, colonialistic imposition. And it's a court that was established by the very UN that had abandoned Rwanda in the midst of the genocide. And so you already had some very negative feelings towards this organization called the UN. And a lot of that was operating on the side of the outreach messages that are trying to legitimize the court in Rwanda. And I think what you get in Rwanda are very mixed views about the court. Before even looking into their case law, before understanding what the court has come out with, there are various perceptions that would delegitimize the court before even going into the merits. And then you do have these acquittals, which, you know, the acquittal rate, it was mentioned before, was quite normal at the ICTR. But still, when a very high-profile leader who is considered by a large part of the Rwandan population as bearing the responsibility or sharing the responsibility for the genocide with other leaders, once they are acquitted in the perception of many Rwandans and many powerful government figures in Rwanda, and this is wrong. Acquitting these people goes against reconciliation in Rwanda. So I think it's very easy to argue both ways, all right? You make justice. It's supposed to reverberate on the national level. It's supposed to relieve some of the sentiment of revenge. And also, the other side, which is there's no reparation, there's no rehabilitation. So it's very easy to argue both ways about the contribution of the ICTR to reconciliation. What I think that a lot of these claims overlook is a more indirect way, but nonetheless influential way, in which the ICTR had affected reconciliation in Rwanda. And that is through encouraging the set of legal developments that Judge Johnson discussed earlier: abolition of death penalty, national cases, revision of the witness protection system, the exclusion of life in isolation, the penalty that replaced the death penalty at the time, restructures of the penitentiary system, the new prisons that were built, the courtroom was also reformed. A lot of these processes that are very tangible and very immediate and are happening in Rwanda in recent years have in turn a larger, a wider, broader societal effect that I think is worth looking into. And even though these are sort of indirect effects of the ICTR, they can still be very significant in terms of the number of people that they influence and the length of time that they can continue to influence. So if you take, for example, the abolition of the death penalty, and I think it's important maybe to describe the context a little bit. Rwanda abolished the death penalty in 2007 in order to receive cases from the ICTR, as was already described before. At this point in time, 1,300 Rwandans had received the death penalty for their role in the genocide. All right? Most of them were still on death row in 2007 when the penalty was abolished. So 1,300 individuals who are on death row at the time the penalty is abolished. This abolition affects 1,300 communities, right? It affects the family of those on death row. It affects the families of their victims. It affects their neighbors. It affects very wide circles in Rwanda. And so you can imagine that abolishing at one moment that penalty, it is not setting those perpetrators free. The sentence was commuted to a life sentence. But still, abolishing that sentence at that moment of time had affected many circles in Rwanda. And looking into how that impacted national reconciliation, I think, is the more interesting view, the more interesting question. And that relates to other international tribunals as well. Other international tribunals have very similar effects of encouraging national legal reforms in their target states, right? And very often, those effects in turn would have a reverberation of effects on a wider circle. And I think it's very interesting to look and see what are those effects. With regards to the death penalty in Rwanda, my own research, which was based on semi-structured, in-depth interviews in Rwanda of Rwandans, suggests that many Rwandans, including genocide survivors, all right, those very people who wanted the death penalty originally, many of them later on regarded the death penalty as an impediment to reconciliation. It traumatized the relatives of those who received this punishment. It fostered resentment among their social circles. It prevented the truth from being exposed, as dead perpetrators can never share their experiences. And so when the death penalty was abolished, many of those Rwandans actually considered the abolition to have removed a very serious impediment to reconciliation and allowed more reconciliation to potentially take place. Some of those I interviewed suggested that the mercy that was experienced by the prisoners when and their relatives when the death penalty was abolished helped them go through reconciliation processes. I could sense this as well when I entered the prison and interviewed prisoners who were previously sentenced to death for genocide. Interestingly, 9 death row prisoners that I interviewed, out of 9 that I interviewed, 2 of them had their sentences later reduced, and they were about to be released within a year of my interview. And so these kinds of developments gave hope to relatives of other former death row prisoners that their loved ones would come out. And it kind of had the community, it prepared the community to receiving these horrible perpetrators who received the death penalty, but inevitably would be released into their communities. There was a whole preparation of receiving, and in this preparation, there were acts of reconciliation. Even imagining that day that the perpetrators would be released had caused communities to prepare and for reconciliation. So this suggests that the death penalty abolition had a positive impact on reconciliation processes in various remote villages in Rwanda. So even if international criminal tribunals, and I will conclude with this, even if they're not equipped to directly affect a very highly politicized domestic process, such as national reconciliation, they can still have an overall positive effect on national reconciliation by doing what courts do best, by applying and legitimizing legal norms. Of course, justice itself is important for reconciliation, but justice can affect reconciliation in many different ways. And when justice is delivered on the international level, it may need to be translated to local terms and manifested in national developments before it can meaningfully affect national reconciliation. I think my time is up, so I will thank you very much for your attention.
Thank you very much for Dr. Horovitz for highlighting some of the points that Judge Jensen raised. We don't have time for questions, but since I was asked to let people for 1 or 2 questions, if there are, we'll take them and then we'll go for a break.
Quelqu'un peut me traduire?
תרגם לעברית, זה בסדר.
Oh là là, c'est les cadeaux qui se donnent.
Bon, c'est pour vous demander, vous les deux, à propos de la protection des témoins au tribunal pénal international pour le Rwanda. Nous avons eu beaucoup de problèmes de personnes qui sont allées témoigner à Arusha et qui ont subi les conséquences. Et aujourd'hui, j'ai un homme qui vient à mon bureau, très traumatisé, et qui a témoigné dans le procès de celui qui était ministre de la planification, Ngirabatware. Et cet homme, il est très menacé par les familles et les amis de Ngirabatware. Il a quitté là où il habitait, il est allé habiter ailleurs pour fuir. Malgré tout, les familles, tu vas pouvoir tout dire?
Oui, bien sûr.
Ah oui. D'accord. Ah oui, j'avais oublié. Et alors, ils sont, attention, donc pour vous dire, l'idéologie de destruction qui est encore là, ils ont même manipulé Ibuka de cette place-là, c'est dans Rubavu, à Gisenyi. Ils ont manipulé le responsable de la cellule. On lui a refusé l'attestation qu'on donne normalement aux rescapés pour qu'ils aient des droits au fonds d'assistance aux rescapés du génocide les plus vulnérables. Il n'a pas de logement. Il a des enfants qui sont venus avec sa femme pour témoigner parce que c'était son voisin immédiat. Et aujourd'hui, ils ont même, les voisins, la famille, donné de l'argent pour que ceux qui devaient témoigner contre lui témoignent pour lui. Malgré tout, il a été condamné. Aujourd'hui, qu'est-ce que le tribunal peut faire? Parce que moi, j'ai été limitée dans le travail que je fais. J'ai pu exiger Ibuka d'intervenir dans les instances de base pour lui donner son papier auquel il a droit parce qu'il a survécu. Mais d'ici, pour construire une maison pour lui, il y en a beaucoup qui n'en ont pas. Qu'est-ce que le tribunal pénal international peut faire pour intervenir et nous aider parfois à aider ces témoins? Merci.
השאלה הייתה, עדים שהולכים להעיד בבית הדין הבינלאומי בארושה מאוימים על ידי המשפחות של הנאשמים, הם מפחדים ללכת, והביאה מספר מקרים, כולל מקרה ספציפי של אדם שר לשעבר בזמן הג'נוסייד, שאנשים שהלכו להעיד במשפט שלו ניזוקו. זאת אומרת, הם היו מוכנים לשנות מקום המגורים, המשפחה שלהם נרדפה ואוימה, ומספר אנשים שזכאים לסוג מסוים של פנסיה כניצולים, הפנסיה שלהם נשללה או נדפקה, לא זכתה להכרה ראויה אחרי שהם העידו במשפט. והיא שואלת מה בית הדין הבינלאומי יכול לעשות בכדי למנוע מקרים כאלה, כי היא מונעת מהאנשים שסבלו לבוא ולהעיד.
Judge Jensen, can you come up and respond? Thank you.
I understand from the question that the witness testified for the prosecution. And
Pour le procureur.
Yes.
for the prosecution, but he's living in a Hutu environment where the general population is very sympathetic to Inge Batware, who did a lot of good things for the Hutu population in the area. But I mean, the fact that his prosecution witness actually shows that sort of the disclosure of his identity doesn't come from us or from the Rwandan prosecution, who often has to assist us.
But she asked.
Yeah, I get to that.
Sorry.
I just want to sort of clear. Yeah, but sometimes people get to know that their neighbors have gone to Arusha. It's not common that you suddenly leave your village and then you are away for 2 weeks, which witnesses usually are, and then you come back with money on your pocket. So very often the neighbors will sort of guess that you have been to Arusha, and maybe they have identified you as a sort of a possible a witness in advance because of things you have said or things you have done. But what we have a witness protection unit in Rwanda. It's based in Kigali. And we have witness protection officers there who can help. And one solution could be to remove and help the person to relocate elsewhere in Rwanda. We have done that in a number of cases. Of course, the person can also report it to the police, but often the offenders are anonymous. They throw a stone through the window during the night and so on. That's what we have heard. So they're very easy to detect, and probably you will not get a good life if you report your neighbors to the police in a neighborhood environment that is hostile to you. But my answer is contact the witness protection unit in Kigali, and they will take it from there.
J'ai contacté le parquet général. C'est le parquet général qui m'a donné le problème de l'insécurité de cet homme qui était au tribunal pénal international, mais qu'ils ne peuvent rien au-delà de ça.
I have been to our division in Kigali several times. They have an open door policy. They even have a medical clinic which is much better than the one we have in Arusha, which gives free medical aid to witnesses who have testified before the ICTR. They have a very open door policy. It's only to go and knock on the door. It's in central Kigali. Yeah. Okay.
Thank you very much for the participants and for the audience.